This is the Doc Nation podcast. We are a movement founded by doctors, for doctors, dedicated to empowering medical professionals to reclaim control over healthcare decisions and advocating for their fair share of the industry's resources. Please note, the views expressed are those of Doc Nation and not necessarily those of our guests or referenced health centers.
Hey everyone, thanks for joining. We have Steve Stratman, the longtime lead attorney that has been supporting our physician for years and years now. And he just goes above and beyond in terms of trying to understand healthcare and being prepared and ready for questions that he thinks that physicians will have in the future. And so we're very, very grateful to have him as leadership on our team. And without further ado, I'd like Justin to jump in with the first question. But thanks for being with us here today, Steve.
You bet. Thank you.
Steve, tell us about how you got involved with healthcare and the role you play in it.
Oh, sure. Thanks, Justin. Well, I've been practicing for a good while, and I was in private practice with a large law firm for about 15 years. And then I was with a large public company as the deputy general counsel for another 15 years or so. And then I retired and have been in private practice part-time since then. But about 2017 or so, Justin and Reed contacted me to help them out with some physician contracts. And so since that time, I've been focusing almost exclusively on physician contracts, employment agreements, helping physicians with their practices in varied ways. And so I guess since about 2017, I've been full-time in the healthcare practice vis-a-vis my law practice.
Awesome. And this year's been a big year with some of the announcements that have been made around the non-compete, potential changes, and then taking those changes away. Can you talk to us about what's going on there?
Oh, sure. The couple of months ago, the Federal Trade Commission proposed a rule which was going to ban non-competes really across the country. And it was a sweeping rule which would have had the impact of effectively eliminating non-competes in all the states where they're currently allowed. And ballpark, it's about 40 states that currently allow them. And so the FTC rule was supposed to go into effect September 4th, just 2 days ago, but it was enjoined by a couple of courts, actually. But it was enjoined on the basis that they really didn't have the authority to issue such a broad-based rule. And so it sits right now as an enjoined rule. And my personal professional opinion, Justin, is that it's probably not going to come back. And so that while it's under appeal, and these injunctions, as you guys know, can go for months and months, and they can go through the appellate court process and things like that, I think that based upon some recent Supreme Court decisions, I don't think the authority of the FTC will be upheld. And so my prediction to just go out there on the limb is that it won't be revived, which then puts us back to the status quo before the rule. And the status quo before the rule is that in about 40 states, covenants not to compete are enforceable, but they've got to be reasonable in their duration, and they've got to be reasonable in their geographic reach. And typically, they cannot impose a substantial hardship on the party who's bound by them. And so that those are the three touchstones that you encounter in most states where they are permitted. But again, those are just the legal implications. The practical implications of a non-compete, when doctors encounter them in their contract, include things like, will the employer even try to enforce the non-compete? Because remember, an employer's got a few considerations here. They include the cost, they include the expense, they include the reputational damage, they include the potential that they could lose. And so if they lose, then in that state or in that area, it sets a precedent that a non-compete against a physician is not enforceable. And therefore, the employers are a little bit hesitant to actually go after and enforce a non-compete, even if they have one in their contract. But it is a little bit of a misnomer, Justin, to your question. It's a little bit of a misnomer, and I encounter it often with the doctors I talk to. Sometimes they'll come and tell me that, gee, the non-compete in my contract, but it's really not enforceable, right, Steve? And I'll tell them that that's misleading, because in many states they are. And the employer is not going to include a non-compete in a contract in a state where they know it's permissible. And so you need to go in assuming that it could be enforceable. And then you get into the notion about, is it too broad? Is it too long? Or will the employer even try to enforce it? So those are kind of the legal and the practical implications that doctors need to think through when they see a non-compete in their contract.
That's great, Stephen. And coming from a physician, one of the biggest things I hear from other physicians is the same cost and reputation that you're talking about that might occur against the hospital is why physicians are afraid to even try to touch that non-compete. Rarely do they reach out to someone like you. That's something that Doc Nation we're trying to say is, hey, come to us. We'll get you to Steve. We'll get you to look at this. To me, a non-compete in most contracts are just a deterrent, and it works very, very well.
Just a term, you said?
Just a deterrent.
Just a deterrent.
Yeah, to keep people from wanting to change positions. Not many physicians that I have seen have gone against their non-compete and actually fought it, even if they would win. Would you agree with that?
I would, Doctor. That's a great point. You're exactly right. There certainly is a huge advantage to an employer including them in the contracts in a state where they can, because to your point, in the views of a physician who's not used to them and just reads the print, they think that, wow, this is going to be a hurdle I cannot get over, and I need to take that into account should I ever leave the practice. When in fact, to your point, it can be hurdled. And it also can be negotiated away. It can be liberated in the sense that it can be made more liberal in terms of the terms. The periods could be shortened. The radius could be shortened. You could carve out exceptions, to your point, Dr. Anthony, about exceptions if, for example, the doctor is terminated without cause. What if the doctor terminates the agreement for cause? There are a lot of reasons that justify either the elimination or the non-applicability, or certainly the liberalization of the non-compete, such that it is very, very narrowly drawn, even if it continues to exist in the contract.
Can you speak
I love
to? Oh, go ahead.
Last point, just to get out to the people out there that are worried about their non-compete, always ask the right people. Someone on the law side will help you. We don't know this. Physicians, this is one thing we're really not good at, is our contracts. Make sure you reach out to someone, ask if there's something you can do. Don't just take it at its face value and say, oh, I'm in trouble. I got to move out of this whole state if I want to keep practicing.
No, that's great advice. And the other thing to bear in mind is, again, to your point of deterrence, the physicians, they just can't know. Why would they know? But the American Medical Association has spoken out against non-competes. They view it really as an ethical issue, therefore reducing accessibility to medical care. So the AMA is very clear in their view about the enforceability of non-competes. And courts, generally speaking, in most states that permit them, they are very much disfavored in the law. And so if a court takes a look at a non-compete, they're going to look at it in a sense of narrowing it, applying it, if they apply it at all, in a very narrow way. And doctors also need to understand that if they pursue a non-compete, judges have multiple rights in different states. Some states can, in some states, the judge can just cross out the non-compete completely and just say, hey, this is against public policy. I'm not going to enforce it. Go away. Second thing they can do is they can take out their pen. They call it blue pencil. And the blue pencil rule allows the judges to modify the non-compete as it may be written so as to make it more reasonable within the contours of the state law. And so physicians need to understand that they have multiple options when they encounter a non-compete. And I agree with your advice that they should press the issue, because it can be modified in the final contract to make it not as enforceable and not as broad, or they may be able to even negotiate it out of the contract. And the last watch out I'll have for you is this. Employers will tell you all the time that the non-compete is non-negotiable. It's non-negotiable. It's all of our agreements. We don't talk about it. We can't change it. There's nothing we can do about it. You just have to live with it. But in many, many cases, that's just not true. It's just not true. And when you get down to the final issues in a contract negotiation, especially if the employer wants this position badly, maybe it's a niche they've been trying to fill. Maybe they've been at it a long time. Maybe it's a specialty that they very much want in their integrated practice. They can bend, and they do bend when you get down to some of the final issues.
These employers need doctors more than doctors need the employers, because the time is with the shortage and the retirements and people leaving, that they need. The need is so great. Steve, talk to us about, we have signature members who are in private practice, they own their companies, and we have members that are employed. Talk to us about how to think about this from both perspectives, because obviously you want to be able to protect, as an owner, what's proprietary, what's unique, the effort, the investments you make into somebody. So there's a little bit of a line to kind of walk here, because on the one hand, there's some benefit to these on one hand, but on the other hand, it can be, to what we were just talking about a moment ago, it can be bad for patients getting access to care. How should we think about this in the current situation that we're in now, that, as you said, it might potentially be blocked and not brought back up again?
Well, I think that you raise a good point, Justin. Depending on who you represent and depending on your status. For example, Justin and I were working just 2 days ago with a practice where they want to hire an additional physician. And so when Justin and I assist a doctor who might be the owner of a practice, well, then our advice might be a little bit different in terms of how you might construct the non-compete. And so different from what we've just talked about in terms of opposing a non-compete. If you're an owner and you want to protect a lot of things, you want to protect your business, you want to protect your patient panel, you want to protect your employees, you want to protect the confidentiality and the business strategy that you've employed as an owner of a practice. Well, then in those cases, sure, you're going to write a non-compete if you're permitted in that state to write one. You're going to write one which is, to your mind, reasonable. And so oftentimes in many states that permit them, there might be a corresponding state statute. And the state statute might lay out the contours of what is presumptively permitted, presumptively enforceable. And those can be your guidelines if you're an owner to say, well, wait a minute, if the statute permits a non-compete of no more than 2 years, well, then go ahead and write a non-compete of 2 years. And it permits a geographic restriction of X miles from the primary site, then go ahead and write it that way. And you're remembering, if you're the owner, you're saying, hey, wait a minute, I'm not trying to be difficult here. I'm not trying to be unfair, but I am trying to protect a business I've built up for many years, and a patient panel I've built up for many years, and a business way of doing my business, and a business strategy and things like that, and confidentiality, and maybe even some patented procedures or products that I've built up and I want to protect. And so you can see why those are justifiable reasons for a physician who's an owner to go ahead and impose a non-compete, which is reasonable in its geography and it's reasonable in its duration.
I'll just give you an example too on that same note. We had a client who went to their employer and said, hey, I want to start a separate practice, a telehealth practice regarding weight loss. And they said, no, you can't do it. And then they came back and said, well, maybe under these conditions. And then they came back a third time and actually said, well, I'll allow you to go ahead and do it. And he was going from inpatient internist medicine to weight loss, which there's no conflict there. There's no like, the patients that are coming in for inpatient care are not going to be, he's not going to be building an inpatient center. He's going to be helping people on an outpatient basis with weight loss. And so stuff like that, to the point of them saying no, they actually changed their mind, and it turned out to be a really good situation for him in the midst of pursuing this opportunity that he had in mind. So there are avenues, to your point. It is possible. Do you have any other thoughts, Steve, on the future in terms of how doctors should plan around the environment that we're in?
Well, a couple things. Yeah, a couple of things, Justin. Thanks. And to your point, before I move on to the next one, where you practice, meaning the specialty in which you practice, is really important in the non-compete, because the employer might send up, whether you own it or whether you're going to work for an employer, they might send up a non-compete, which is very broad and says, hi, you can't practice medicine in a particular area for a particular time. But to your point, Justin, the physician needs to pause, or the owner needs to pause to say, well, wait a minute, what type of practice is this physician practicing? Meaning, if it's a hospitalist, the hospitalist doesn't have a patient relationship which is transferable in the main.
Yeah.
They're doing the work at the hospital and they're serving whoever they serve for a particular day. They're not a threat to the financial business should they leave. Same in some other specialties, maybe a radiologist, maybe some staff pathologists. It just depends. But they can always pause to say, hey, wait a minute, why should you be concerned about me walking down the street to become a hospitalist at another hospital, even if it's within the geographic restriction? Because I'm not going to take your patients, so I'm not a risk. But in any event, to your broader question of the future, a couple of things. One is the status of play on non-competes is very fluid, and the FTC rule demonstrates that. While it was enjoined, and while I don't think it's going to come back on a national scale, these things are under strict scrutiny. And so any physician, whether you're an employer or you're an employed physician, will need to be mindful of the landscape. And the landscape is right now, state by state, these things are getting eroded. They're getting eroded. And so, for example, just in the last couple of years, there have been a number of states who have banned non-competes. Minnesota has banned them very recently. Pennsylvania bans them as of January 1st of 2025. There's an exception in Pennsylvania for 1 year, but in any event, the concept is that the governor signed the statute just a few months ago. But Pennsylvania recent, Minnesota recent, South Dakota a year ago. And so state by state, these things are getting scrutinized. And so physicians need to be aware, no matter what side you're on, they need to be aware that the landscape is changing. And so the doctor needs to be very mindful of what the state law is at this time, because they can be shifting legislative session by legislative session. The other thing which, Justin, at least I recommend, for example, if I represent a physician, is to say, hey, wait a minute. Okay, we've tried our best. We've narrowed the non-compete best we can, but it's still there in some form. And so I'll put in kind of a caveat clause, which just says something like, hey, whatever happens with regard to state or federal legislation, which may restrict, narrow, or ban a non-compete, the non-compete in the foregoing clause will immediately become void and unenforceable, effective as of that day. And so I just call it kind of a springing clause, which immediately eliminates and voids the non-compete, which they've tried to get out of, but have failed. But the springing non-compete hopefully acts as a spring that says, hey, if any legislation changes, federal or state, then immediately this non-compete will perish.
I have a question, and many other physicians listening might have the same question. I think we're afraid of the unknown of how much it would cost to fight a non-compete. I know you can't give me an exact number. Do you have a ballpark number on how much it would cost if you were to hire a lawyer or someone like yourself? That's a lot that we have no clue, and we're afraid to even go down that alley sometimes.
Right. No, that's a good question, and that kind of is a cousin to the deterrent, because as you know, it can be costly. I mean, bottom line is, yes, it can be costly. And so any lawyer you're going to hire is going to handle the case probably at his normal or her normal hourly rate. It's probably going to be at a minimum of $300 an hour, but could be as high as $500 an hour. Just depends on your locale. They've got to file their complaint. They've got to go ahead and take whatever evidence they take. They've got to file their brief and do their legal research. They've got to argue the case before the court, et cetera, et cetera. So the short answer is it will be easily several $1,000s. I mean, easily, $10, $15, $20,000, because you can see those steps. And of course, as you guys know a little bit too, in litigation, there are all those intermediate steps. It's called discovery, but you can go back and forth, and you can have interrogatories, and you can have requests for admissions, and you can take depositions, and you do all kinds of things, which delay for number one, and then add costs for number two. But doctor, one clause that I always put in these provisions is, again, if I represent the physician, is to say, if this non-compete is ever successfully challenged, then all the legal fees and all the costs attendant to a successful claim to enforce the non-compete is borne by the other party. And so my position is, hey, if I'm confident enough to take the case and can recommend to the doctor that I think there's a more likely than not chance or a probable chance you're going to win, well, then I'll go ahead and make certain in that clause, all the legal costs that doctor incurs have to be paid by the losing party, which in that example is the employer.
Well, that's great to know. I mean, I think that's really important for people to hear.
The other thing too, doctor, to bear in mind, and it's not in every provision, on every clause, in every contract, but do bear in mind that litigation is expensive, it's costly, it's just a sinkhole. I always advise against it, in favor of arbitration. And arbitration is a quicker way, it's a cheaper way. The arbitrator has the same power as a judge, and you go before a single arbitrator and you make your argument, and that arbitrator can decide. And then again, I have the same provision, which is, and if I'm the prevailing party, then all of my costs are paid for the losing party. And so again, both sides have to be sober about whether they want to pursue it and how confident they feel. And then along that path, of course, could be a settlement. And along that path could be the employer gets nervous. The employer gets nervous because one, they could lose and set a very bad precedent in their state. And number two, this could be costly. And so they could privately settle the case that just says, hey, just between the two of us, I'll let you out of the non-compete on some pretext of, hey, you're going far enough away, even though you're within the boundary, or
Yep.
I don't see you as a threat. And so I'll let you out. But hey, this is a confidential settlement. Keep it to yourself and go about your business.
That's an awesome segue into the question I've been wanting to ask Justin, actually. Justin, that client that you spoke of, one of our clients, did he hire a lawyer? Or was he just taking steps based on the direction that we were giving him?
That one, there was a lawyer involved in that client situation, but it was more so for the business. It wasn't for that aspect. We were able to actually get those movements made without having to cover.
So before you may need a lawyer, Doc Nation loves to negotiate contracts, is what I'm trying to say. And there's a lot of things that if you can say, hey, I'm represented by Doc Nation, and they've seen thousands of these a year for about 15 years running now. Hey, there's some things that we can do before we need to hire a lawyer. So I love that you say that, Steve, because we do see a lot of, hey, between us, we'll bend a little bit. We'll bend this contract a little bit. We see that all the time. I think the issue, and they've just gotten comfortable. Administration has just gotten comfortable with saying everybody just says yes to things we say.
Yeah.
And really, in a large part, when our client, that he said, okay, I guess we got to do something different, and we said, hold up, no. Let's have a conversation with this group. Let's push back a little bit, and we saw what happened. It was completely wiped.
Yeah, I like what you said, Steve, about that. That so many are afraid, they're shy, they're timid, they think they're going to rock the boat, they're going to lose an offer or start off on the wrong note with the employer or have a bad reputation or something high maintenance, and so they're scared. And when they get good counsel that has been there, done that, that's seen these before, that can give them defensible, reasonable, common steps, language, insertions, modifications, employers are willing to accommodate. They make adjustments.
There's almost a respect that is given to the physician to say, hey, they're buttoned up. They have representation, and they care about what they're doing enough to have a team behind them. And there's almost a certain level of respect when starting a new job.
Oftentimes, too, you raise a good point, Reed, about just the negotiation process, because in the negotiation process, the doctor might raise a number of issues about compensation, for example, or PTO or things like that. But oftentimes, as always happens, there are trade-offs, right? There are trade-offs. And oftentimes you might get to a point, and I've seen this many times, and so have all of you, you'll get to a point where they're good. They can live with whatever the compromise was on compensation or whatever. But oftentimes I'll counsel the doctors, if they're on the physician side, to say, hey, I can live with this and I can live with that. And one tactic might be to just go back to them to say, employer, I'm ready to go. I'm ready to sign the agreement. I'll accommodate your point on this and that. But I'm really pausing on this last issue. And this last issue is a big one, and it's the non-compete. I just can't see fit to confine myself or to exclude myself from opportunities within a particular geographic location, which could very much disrupt my family life, my personal life, my professional life. And I'm not going to do it. I'm not going to do it. And so while my pen is hovering over the page, I'm ready to sign this contract. I'm pausing until I hear from you that you can accommodate me in some way. Otherwise, I'll pursue other opportunities, which I have. And lo and behold, the non-negotiable, cannot talk about it, don't even raise it, non-compete, gets blown up or gets narrowed or gets modified. And so again, some of it just factors into tactics. It kind of factors into strategy. And how many issues you want to raise, and then pick your ones which are your priority issues. And then again, don't be afraid to play some hardball, because to your points, all of you have made, if you're a physician and the employer is giving you a hard time, oftentimes they need you very badly. and they can wiggle on some issue they thought was non-negotiable or they said was non-negotiable.
And so we're discussing this FTC all sweeping new rule here, and we're putting so much focus and so much attention on it, which we should, but let's also stop and think, hey, that's one thing a group like Doc Nation does is they will help you get what you want. And this ruling doesn't necessarily, it absolutely matters, but there's steps to be taken before this is an all say or all do ruling. There's a lot we can do before we just walk away and say no.
It's not their only hope.
That's right.
You don't have to wait for the industry or a massive sweeping change to occur for there to be improvements. There can be changes to your individual circumstances that are making things better for you.
Yeah, one last point too on that score, Reed, to your point. The FTC rule, even though it's been enjoined and maybe it may not come back, it serves a little bit as a momentum. It's a pusher. It kind of pushes the issue. And so that within the states that permit them, and there's about, high 30s, about 40-ish that permit them, they all see what's happening. And the legislatures, which convene every year, almost take this up very regularly. And so the physicians need to be mindful that not only can they push back if it's permitted and stays in the contract in some form, but they really need the help of Doc Nation, for example, or an attorney who can help them, because literally these things are changing month to month. And Pennsylvania a year ago permitted them. As of January 1st, in 4 more months, they're banned. Same with Minnesota. It happened in the last year. South Dakota happened a year ago this past summer. And so the physicians need to be mindful of calling on a group like Doc Nation or their attorney or somebody to help them, because literally these things are changing month to month.
Awesome.
Oh, by the way, before I forget, some of you, I know you work with and represent physicians who might be under a J1 contract.
There you go.
Or some kind of an immigration requirement with regard to the immigration laws. Those things oftentimes impose their own very specific restrictions on non-competes. And so that, for example, a J1 physician under any state program, and as you folks know, they coordinate with their state medical societies, et cetera. And there are usually 30 J1 slots in many states available, et cetera. But the state programs will oftentimes prohibit the inclusion of a non-compete in any contract where the doctor is practicing in that particular state, regardless of whether the state law might permit them. And so that's a good example of where the federal immigration law jumps over and supersedes or trumps any kind of a state law prohibition. And so if you're working with a physician or advising or whatever, a physician who might be subject to some immigration requirements, be mindful that those requirements could prohibit a non-compete.
Good point.
Thank you, Steve. Doc Nation is strengthened to have you be a part of our team and your knowledge and your consistent research. So thank you for joining. That was a solid 20 minutes. I know this is going to be well received. Have a wonderful day. Thank you, Steve.
Well, thank you for having me.
All righty.
Bye.
Bye-bye.
This has been the Doc Nation podcast. If you like what you heard, be sure to subscribe, rate, and leave us a review on Apple Podcasts, Spotify, or wherever you are listening to us. Your feedback really helps us reach more listeners like you. We'd also love to hear your thoughts and any topics you'd like us to cover in future episodes. Don't forget to follow us on Facebook, Instagram, and LinkedIn for updates, behind-the-scenes content, and to join the conversation. Thanks for listening.